Good afternoon, everyone. Thank you for joining us for our conversation with Russ Feingold. And thank you so much, Mr. Feingold, President Feingold, for joining us for this amazing panel. My name is Dominique Hamilton. I am a 3L and I'm current president of Howard Law ACS student chapter. I'm originally from Los Angeles, California, and I attended UCLA before attending Hustle. While at Hustle, to do my part as a social engineer, I have focused on effectuating change via the social welfare area of law dealing with child neglect and custody issues. I appreciate that ACS has specific sectors that effectuate change in this area as well, such as Constitution with Classroom. ACS is such a well-versed, robust, and amazing organization that it has areas of law for everyone that are interested in effectuating change for social justice and the overall social welfare of our country. I'm going to give it to my co-moderator, Shawn Deadwiler, to introduce himself and keep the conversation going.
Thank you, Dominique. So my name is Shawn Deadwiler, a 2LE student at UDC Law. I serve as president to our ACS chapter here. Want to start off by thanking first President Feingold. We got the okay to go by Russ for today, and my colleague Domonique for sharing their time and putting on this event. A little bit about myself, I'll keep it short. Had a non-traditional track into law school, played college basketball, did some coaching as well. As I transitioned from that, sparked my curiosity for the other side of life. And long story short, that led me to law school. My favorite course is constitutional law thus far, and my purpose for going to law school is to learn how the law and policies help or hurt access to opportunity in marginalized communities. So that's a little bit about myself, and we'll give it to Russ for his opening statement.
Well, thank you, and thanks to Dominique Hamilton, and Shawn Deadwiler for the introductions and for your work at UDC and Howard ACS student chapters. Thanks for inviting me and hosting me for this program. As you know, because you do it, our ACS chapters are the heart of ACS. Our chapters, and we have over 200 student chapters at almost every law school in the country, and also 54, over 50 lawyer chapters. You know, I can tell you, even though it's on Zoom these days, our network inspires me every day and makes me, you know, hopeful about the road ahead, as tough as it seems some days. It's why I joined ACS 2 years ago, and I really believe fervently in the impact this organization has. And I did not know the extent of that impact by any means when I took the job. I have seen it in fact, and it excites me. I want to especially emphasize the importance of the HBCUs. You know, I wanted to make a statement about these law schools when I took the job. My first day on the job was March 9th, 2020, a Monday. I immediately went over at lunchtime and met with the Howard University Law School ACS chapter. We had a great lunch and a great conversation. And you know the rest of the story. If you think of the date, March 9th, 2020, that was the last time I met face-to-face with any student chapter for like a year and a half. And yet it was a wonderful meeting, and I hope symbolic of the importance I place on these chapters and your brother and sister chapters that do special work to advance the cause of law and liberty and freedom in our country. I'm very grateful to have the opportunity to speak at these events, so please include me in the future, especially when we can do it in person. Just a word or two about my background and my career. So I was asked at the beginning by Shawn where I was, and I said, you know, I'm in freezing Wisconsin where I live. I'm supposed to be primarily in Washington if it wasn't for COVID running the organization, but I'm running it from here. And it's about 5 degrees. But this is where my family's been for over 100 years, since the family came here as an immigrant family in 1917. And what was a big deal in our family was the Wisconsin progressive tradition. It's a very left-leaning view of the view that government should have a role in making sure that we're a community and protecting and making sure that everybody's part of the community. You can see the Vote Progressive sign behind me, which is an old one from the 1930s. So, that's one of the strains in our state that inspired me. There are other strains that horrify me. You might have heard of Joseph McCarthy, the horrible communist baiting senator. McCarthyism, that's Wisconsin too. So we have both. But I wanted to make law and politics my career. And so when I finished law school, I practiced law for about 3 years, full-time litigation here in the state. But I always wanted to go into politics, and I did. And I was lucky enough to become a state senator in Madison for 10 years, followed by 18 years in the United States Senate, representing the state of Wisconsin. And that was until, as happens in politics, as I like to say, I was invited to a tea party. In other words, the Tea Party knocked me out in 2010, and I was defeated. But fortunately, I've been able since then to teach law school at a number of law schools around the country. And I was President Obama's special envoy to Africa, and particularly Congo and Central Africa for a couple of years. And now I have the good fortune to be the president of this great progressive organization. And so that's kind of a nutshell of what I've done. But I consider the kinds of issues that ACS gets involved in: civil liberties, civil rights, protecting the right to vote, protecting constitutional rights, protecting the rights of immigrants, all of these things, fighting the death penalty, things like that, are things that have always inspired me. And it's great to have a job where every day I get to get up and work on it. So that's a little nutshell. I hope that's what you sort of had in mind for a little bio, but I'll leave it at that.
Yeah, that was great. Thank you so much, President Feingold. And I believe, even though you've been with us for a short time, you've done a great job. So thank you very much. So we'll get into the questions now. We'll be starting with interpreting and constitutional interpretation. And this question, me and Shawn asked our board members to submit questions so everyone could, have their voices heard. And this question is from our e-board member, Zach Toland. Zach asks, ACS's mission states that ACS believes the Constitution is of the people, by the people, and for the people. We interpret the Constitution based on its text and against the backdrop of history and lived experience. Given this, what do you believe, President Feingold, is the greatest constitutional threat we face today? And how can we, working with ACS and others, work to combat and defeat that threat? So it's a two-part question.
Yeah, I mean, this is the biggest part of our work. We have so many things we do, but the original reason for creating ACS was in 2001, in reaction to the United States Supreme Court's very questionable decision in Bush v. Gore. We realized that was really a political handing of the White House to George Bush, and something wrong had happened to our courts and our court system, with the conservatives and the right plotting already for 20 years with the Federalist Society to take over the courts and to really move us backward instead of moving us forward. And as the questioner knows, and everybody here knows, what they did was try to dress up this sort of raw move toward political power in terminology that sounded kind of neutral and even appealing. So what they did was say, look, what you got to do, the only legitimate thing in interpreting the Constitution is to be an originalist, which means trying to figure out what was meant originally, intended originally by the Constitution, or being a textualist, which means, you just look at the words and you figure out what those words meant in 1789, and then you're off to the races and you can figure it out. Well, obviously that doesn't do the job if you're looking at a diverse society in the 21st century. How can we possibly simply interpret the Constitution based on the words, or what people think are the words, or what people are claiming were the words and the meaning of people all those years ago? For two reasons. One is things have changed dramatically. We're a very different country. Can you imagine what these folks would have thought about the internet or climate change, they wouldn't have had a clue. iPhones, all of that. So it's simply, if the language can't be adapted to the society we live in, including, of course, the fact that it's far more diverse society than the one that existed then, and in fact, even more diverse than the people who wrote the document. And so that's one piece. The second piece is, and this was pointed out to me by students when I taught a course on Article 5 of the Constitution, which is the amending provision, as you know. There were a lot of people that weren't at that table. How can we look at a Constitution and say, well, we're just going to go with the original intent of property owning white men only, or the text of property owning white men? Women were excluded. African Americans were slaves in many places. 3/5 person, still in the language of the Constitution. It's eliminated technically, but it's actually in the text if you look at it. Native Americans. So why should people who weren't even there feel that they have to be bound by something that did not even include many, if not getting to that, in this case, it's well over a majority of Americans now, if you put all those people together. How can you be bound by it if it isn't adapted to life today? And so we believe in, some call it living constitutionalism, others call it legal realism, and others. This Constitution cannot survive as a legitimate document if it doesn't adapt. And so originalism and textualism, apart from being often used in a very phony way, we can talk about that, but even if it's used sincerely, is not enough to govern a country like ours today.
Great answer. So just to clarify, would you say the biggest threat in a nutshell would be the lack of adaptability or the lack of flexibility given to making changes in the Constitution?
Well, it can end up that way. I'd probably say the biggest threat right now is, given the fact that it's very hard to change the Constitution, the biggest threat is that the right has co-opted the Supreme Court. And they are people that believe in this originalism, textualism stuff to an extreme degree. So I think the biggest threat now is they're getting ready to dismantle the constitutional rights, like the right to choose. And they've already dismantled voting rights in a way that shocked me. So the most urgent and immediate threat is what the courts may do, and I think, I'm afraid, will do, because they control it. The larger subject of how do we change the way that we amend the Constitution, I'm actually writing a book with a guy on this. It's like, you don't want them to be able to change the Constitution the way that it would work right now. It would be through a constitutional convention called by mostly right-wing states. That's how it's set up. So we would actually have to amend the Constitution to change the way that we amend the Constitution, to make it a more majority votes kind of thing. We can talk about that more later. But without doing that, it's pretty scary to think about a constitutional convention that would be controlled potentially by 26 conservative states, that represent a very smaller percentage of the American people.
Thank you, President Feingold. I would agree that would be the greatest threat we face today as well. Shawn, I'm going to give you the floor to go into the next question, so we can expound a little bit more on this originalism view of the Constitution. So.
Thank you, Dominique. It's a perfect segue into a question by one of our ACS members, Hunter Pendarvis. He asks, we should be doing more to establish an intellectual framework to push back on the rise of originalism. Why are we fighting on conservatism's battlefield when we could be promoting alternatives such as legal realism?
Well, that's one of the reasons, because I saw that question, I mentioned legal realism. I've taught jurisprudence at a couple of law schools, legal philosophy. And, one of the very legitimate schools that came into being in the 20th century was the legal realist school that essentially says, let's not pretend that these theories of originalism and textualism really explain what the courts are doing. The fact is, the backgrounds and the political inclinations and personal preferences of judges are a factor too. And the legal realists acknowledge that. And that's why we at ACS believe, because we think that that is part of the reality, is it really matters who the judge is and whether the judge is somebody from a diverse background sometimes, whether from a personal point of view, whether the judge is somebody who has ever been on the underdog side, if you will, in litigation. Have they ever represented a union? Have they ever represented a criminal defendant? Have they ever represented a consumer who's being ripped off by a credit card company? So we call that professional diversity. And I will say that and that doesn't mean that these people should rule the same way every time. We don't believe in that. We believe in judges being as objective as they can. But when people come from all one background, or pretty much one background, they end up thinking, even if not intentionally, they end up thinking in a certain way. And they have a tendency to lean, for example, much more heavily toward the corporate view, let's say, in a lawsuit. And it's one of the reasons when I was a senator, I voted against Justice Alito. He was then Judge Alito, because he had like 50 decisions. He voted with the corporations every single time. There was not one time when the guy said, well, wait a minute, this worker here had a point. And so you can see the bias. Now, one of the ways you can do this is by sort of saying, as Justice Kagan once said, we're all textualists now. What you can say is, yes, when you're doing your legal analysis, and I think most law students or lawyers would do this, sure, you're going to try to figure out what was meant originally, right? That's one thing. Secondly, you're going to read the language, right? Okay, that's the textualist. All right, so you do those two things. But the analysis doesn't have to stop there. And you shouldn't be taken in by the fact that they only use that when they want to. I'll give you a great example. The Eighth Amendment, as you know, bans cruel and unusual punishment. And, I believe throughout my life that means the death penalty should be unconstitutional. And I believe we'll get there someday. The court even basically said that once, and then it was overturned. Now, what the right says, claiming to be originalist, is, well, in those days, there was the death penalty. So they couldn't have thought that the death penalty was cruel and unusual punishment. Well, that's not what they decided to say. They didn't say it's okay to have the death penalty. They could have said that. They said there shall be no cruel and unusual punishment, which I think is an invitation to future generations like ours to say, okay, what's cruel and unusual punishment now? And I think now it's clearly death penalty. I also think some of these, the incarceration of people without parole, often minorities, often African Americans and others, is also in that category. So you can say, look, you can say text, you can say original, or you can say the reality of how this happened and the reality on the ground today of the racial implications of the death penalty. You can, whatever one of those you come up with, you can present a good case. And that's the way that I think we, those of us who are progressives on the law, should do it, and not let them get away with closing off the debate by suggesting that some practice in 1789 is the end of the story.
Thank you. You made a lot of good points there. And personally, something that struck me during my first year of law school taking contracts is the use of the reasonable, prudent person standard to determine a party's actions. And again, at a very non-traditional track, and I believe a lot of HBCU law students have a non-traditional track in the law school, and just concepts like the reasonable, prudent person, which is used across the board. In my opinion, people that are not exposed to the law they don't know these things, and these things aren't difficult to understand. And if this type of information was shared in a broad way, I believe that, to your point, Russ, I feel like you have a motivation, a passion to go back and amend and reinterpret a lot of the language from the past. Hence the Eighth Amendment, cruel and unusual punishment. That's an invitation for future generations to explain what that means. just personally, I feel like a lot of these concepts aren't that difficult to understand. And people that are not exposed to the legal field, if they were to know these things, I think that builds a coalition to possibly get to the table of a constitutional convention, which is very far-reaching. That is not easy. We haven't done it in centuries. But I do believe, and I know a lot of our members at ACS, we come from different backgrounds and we have different opinions, but we all agree that to interpret language from centuries ago and have that be the priority we give the biggest weight to, right. It seems to be a little out of touch. So that's just a little, go ahead.
No, go ahead. Finish your question.
No, that's just a little bit of my kind of personal thoughts. And again, like you made a lot of good points.
Well, I love what you said about the reasonable person standard. I mean, who the heck is this reasonable person in our society today? Maybe walking down the street in Quincy, Massachusetts in 1789, everybody might think the same way. But, you know, if you live in a gated community somewhere out here in some fancy neighborhood, what is reasonable to you is not the same thing that's going to be reasonable to somebody walking on in the central city in Baltimore. And as was said to me, when I came to Howard, I was talking about the rule of law. And one of the students stopped me and she said, Feingold, Russ, you know, for some of us, when we walk down the street, the rule of law doesn't sound so friendly. The rule of law can be something different. The rule of law can be the repression of the law that has kept these communities in a very tough situation. Take another example from the original language of the Constitution. We know that in the Fourth Amendment, as you were suggesting, says no unreasonable searches and seizures. Okay. I think somebody in that gated community is going to think differently about what's an unreasonable search and seizure than somebody who's just standing outside of a grocery store in downtown Philadelphia, and so all of a sudden the cop pulls them over or starts, you know, questioning them or arresting them and taking stuff from them. I mean, the words unreasonable are not the same for everybody who live in completely different situations. So we have to start challenging this idea that it's all about some kind of a idyllic world where you can determine the same idea of what is unreasonable for everybody. And so I just find what you said intriguing. And in fact, we had a number of programs last year focusing on what's the Law and Political Economy School. The right put forward the Law and Economy School. The Law and Political Economy School is a number of academics and others are saying, you know, the way some of these courses are taught in the law schools, like contracts, like torts, is really taught from a classic capitalist, laissez-faire viewpoint that essentially says, oh, no, it's just the reasonable man. It's really inappropriate for the government to get involved and to try to balance these things. And so the curriculum itself is tilted. You know, I remember a great example when they did a program last year about, you know, getting people to be able to talk about environmental stuff. Well, the corporate course is over here, right? You take a course called corporations, and then maybe you take a course about the environment. That's over here, as if they have nothing to do with each other. And of course, they have everything to do with each other. But it's not taught like that. It's taught like, no. Here's how it should work for corporations. And then, well, if you want to consider the environmental impacts of this, that's a whole different subject. It's not a different subject. And we have to change the law school curriculums to make people not feel like they're misunderstanding somehow. If they say, well, wait a minute, how are we ever going to protect the environment if we can't question some of these elements of corporate law? So anyway, I'm filibustering a little bit, but I'm enjoying your questions.
It's good to know the filibuster can be used in a positive way at times.
Occasionally.
Yeah, occasionally.
But maybe not. Yeah.
So thank you for that, and we'll kick it over back to Domonique. Next question.
Yeah, thank you both for those insights. I totally agree in terms of the reasonable person standard, and also even going so far as to looking into law school and changing the way we're taught about the law, because that changes the way we think and the way others think about the law. So definitely, definitely agree. So just to keep it on course, I will go to the next question from our VP, Kufir Lang. And it's on the same topic of originalism, textualism. So one of the great conservative legal movements or greatest successes is that it has developed and advertised originalism and textualism as a legitimate method of constitutional and statutory interpretation. So much so that there are some academics and jurists who argue that these two approaches are the only way to read the text. The progressive movement, on the other hand, does not have a recognizable framework. To what degree is ACS thinking about engaging in a battle to brand a theory of constitutional and statutory interpretation? And what would that process look like?
Well, as I was sort of suggesting in answer to the other questions, the process has to look like questioning, to a degree, some aspects of the legitimacy of the document that they're using. In other words, put them on the defensive. How is it, you could say to those folks, that you can argue that a diverse country in the 21st century has to adhere to the strict intent of people who had no idea what kind of a society this would be and could not even anticipate the challenges we have? So in other words, not only attack the fact that it's conservative, not only attack the fact that it's incomplete, but even point out that it's potentially obsolete if it's not adapted to a more modern application to the world we live in. And secondly, you have to account for the fact that what we called in our 20th anniversary of the organization last year, the founding failures of the Constitution, that much of it was founded on a racial and other kinds of bias. And if you don't have a school of thought of constitutional interpretation that takes that into account and is willing to remedy that, then you have failed to keep the Constitution as a living document. Now, you know, today the court agreed to hear 2 more of these cases on affirmative action. You know, affirmative action was an attempt to say, wait a minute, these founding failures have led to a systemic discrimination against African Americans and others forever. And that has to be changed. And we have to be able to do things to change it. And the Constitution has to be flexible enough for that. But they're still at it. So that's why we can't just play in the field of originalism and textualism. We have to talk about as some of you have suggested, a legal realist approach or a living constitutionalist approach that says this Constitution itself will no longer be viable or legitimate if we don't use a different approach like that.
Yes, great answer. Definitely need to change our approach. And then this also kind of goes to the court. So Supreme Court, and it needs to reform itself. So that's kind of like where our next questions get into Supreme Court reform and the importance of the courts, because they are the ones that are interpreting this Constitution. Why are they still upholding certain failed standards here? So I'm going to give it to Shawn to move over to that topic.
Thank you, Dominique. So next question, again from Hunter Pendarvis regarding SCOTUS reform. Given that there doesn't seem to be an appetite to expand SCOTUS, do you think there should be a push to expand the federal bench at the district and circuit level? A little context he shares, there seems to be a consensus that the bench is overburdened and hasn't been expanded since the early 1990s.
This is a huge subject that we've spent a good part of the past year on. Let me first say that absolutely we should expand the lower federal courts in many places because they simply don't have enough personnel. You know, the Central Valley, California, I guess in some places, I think Delaware and some of these places, it's unbelievable what the backlog is. But I am going to say that I think what has happened in the last few months has led to a greater appetite for reform all the way at the top. And I don't think we should give up on that. So just to give you the context, you know, I'm a lot older than you guys. So when I was young, it was the Warren Court. No, I don't remember Brown v. Board being issued. I'm not, you know, I was around, but I think it was a year old or whatever. But essentially, I got a chance to see what the Warren Court and what the Supreme Court could do if it was operating in a sort of above board manner. And that's what this means. It means that in those days, justices did not just do what the political party of the president that nominated them wanted. Earl Warren, the famous author of Brown versus Board, was the Republican governor of California from Bakersfield, California. And my wife is from Bakersfield. That's not a liberal place. He was appointed by a Republican. And William Brennan, many consider one of the great liberal justices of all time, was appointed by a Republican. Sometimes it went the other way. Some people didn't like it when President Kennedy nominated Byron White, Wizard White. He was pretty conservative. Well, here's the point. What I liked about the court, and what a lot of us liked, was you couldn't tell for sure what they were going to do because they were acting like justices. That's changed. What has happened, particularly in the last 10 years, I would say even 15, 20 years ago, it wasn't like this. In the last 10 years, the Federalist Society and others have basically been given the right by people like Donald Trump to basically pick people who have been pre-screened. People who have been made a promise in law school that they were going to be anti-choice, that they were going to promote the broadest opportunity for gun ownership humanly possible, that they were going to be limiting individual rights. In other words, they had to sign on to a right-wing agenda, which is totally wrong for a judge. And so if you had said to me, Shawn, 10 years ago, would I or ACS be supporting increasing the number of justices or term limit for justices? I would have said, no, that's a terrible idea. We've changed our minds. And the reason we've changed our minds is the process has been totally abused. And this, of course, the big sort of crossing the Rubicon moment was when Justice Scalia died. When Justice Scalia died, Barack Obama, who had been elected overwhelmingly reelected by the American people, had nearly a year left in his term. He was guaranteed under the Constitution the right to appoint a successor. And yes, the Senate had the right to say yes or no, but the Senate had no right to ignore it. And that was by hundreds of days, the longest delay ever on a Supreme Court nomination. The longest one before had been for Justice Brandeis, who ended up being one of the greatest justices, but that was only 126 days. This is like 300 days. And of course, Merrick Garland never even got a hearing. Outrageous abuse of the process. As far as I'm concerned, an illegitimate stealing of the seat. Well, they did it again. Justice Ginsburg, sadly, dies just before the election. What do? They don't have a normal process. And I know something about this. I was on the Judiciary Committee for 16 years. I was involved directly with 4 of the confirmations of 4 justices, 2 Democrat and 2 Republican appointees. We never did anything like this, where you jam through a nomination in 3 weeks before an election. So they stole that one too. Both of them were stolen from Democratic presidents by people like 50 years old who are going to be on there when you're old like me. This isn't right. And so they have delegitimized the court. And we have come to the conclusion at the American Constitution Society, there are a number of reforms that need to happen. One is you got to change the composition of the court. Maybe by adding seats. You can do that. There's no constitutional prohibition on that. You also could do it by having Court of Appeal judges sit on panels with Supreme Court justices. There are a lot of ways to do it. Another thing you could do, it might require a constitutional amendment, is term limits. 18 years. The conservatives were the first ones to propose that. Some liberal scholars have too. Maybe an 18-year term limit. Some people say, why don't we have each president get to pick 2 justices? 2 years, 2 years, so that everybody knows it's coming, and then you have this 18-year limit. That person could still serve as a senior judge or serve on the Court of Appeals. They don't have to be kicked off a court or being a judge. So that's another thing that I think we should consider. The third thing is, doing something about what I'm sure you've heard about, the shadow docket, where they're taking up huge decisions like that Texas decision in private, without hearings and without an opinion. They don't have any ethics rules for conflicts of interest for the Supreme Court, even though the lower court judges do. And you could have the Senate pass rules requiring a minimum and a maximum number of days to consider Supreme Court appointments. You could easily do that. That's right there in the Constitution. So I just did a debate on this for the New York Times podcast called The Argument, if you want to check it out. Where I debated one of these conservative guys about these proposals. But my view is we don't have to just fight for lower court additions. We do need to do that. But we should fight for change in the Supreme Court itself, and we should be aggressive about it.
Thank you. Takeaway, do not give up on reforming the Supreme Court. And those are some really good suggestions at the end that personally, I'm going to go back and rewatch this recording. So that's all I have for that, and we'll kick it back to Domonique.
Yeah, I just wanted to highlight a little bit what you said about justices acting as justices and not voting or not making decisions according to the political party or president that appointed them, because you are in the highest court. So despite your political agenda or the president's political agenda, they definitely need to remember, you are making decisions for the entire country. And the entire country is not one political party. So
if I could just say something on that, because I'm glad you highlighted it. I mean, think about how crazy this is, that you have somebody like Ginsburg, who was obviously very ill, just trying to hang on so a Democratic president could, appoint her successor. Kennedy clearly gamed this thing, retiring that way. This is not what the founders of this country must have intended for an independent judiciary. So I'm glad you mentioned that.
It kind of segues into our next question, which is from Kayla Alexander, our community outreach coordinator. So recently, the Supreme Court revoked President Trump's request to block the release of White House records in an 8-1 vote concerning the domestic terrorist attacks on the Capitol last January. So given that there are now 3 Trump appointed justices on the bench out of 9, what do you think this decision means, not only for the future of the decisions of the highest court, but the future of democracy in America?
Well, obviously it's positive, but we can't get carried away with being excited about it. I mean, to some extent, these justices who are now on there for life and might be on there for 30 years, they probably don't want the whole system to fall apart and come under the rule of Donald Trump either. Because believe me, they wouldn't be around long either if Trump had his way. They're going to rule the right way on some of this stuff, I think, especially relating to separation of powers when it comes to an attempt by somebody who essentially tried to overturn the election. So that's good. And we can look forward to more decisions of that kind, I think. However, having said that, while they're doing that on the one hand, and I'm sure using it as a way to say, look, we're fair, we're unbiased, then they're going at the same time in a completely bizarre way after a woman's right to choose, and they are dismantling the right to vote. They took the Voting Rights Act and cut it up, and in a way that is completely unjustified. And so, although you have to be fair and you have to say, look, at least that was a good decision, that doesn't make the composition of the court legitimate. And it doesn't undercut the fact that undercutting the voting rights is more fundamental than anything. And they are definitely doing that, upholding extremely partisan reapportionment and all kinds of other abuses. So I think it's important to be rational and calm about when they've done the right thing, but not hold our fire on the very big attacks that they are unleashing on democracy, particularly on the right to vote.
No, I definitely agree. And you already touched on voting rights, which is going into our next section. in the state of voting rights right now. So I'll give it to Shawn to ask that next question.
Thank you, Dominique. So this question is from myself. I apologize if it's a bit wordy. Russ, what are your thoughts about the intersection between voting rights and the use of the filibuster? And additionally, any similarities or differences you see in relating to current politics and the position of SCOTUS compared to SCOTUS and politics during Reconstruction and Jim Crow? And for a little context for the participants, an example could be states' attempt to avoid violating the 14th and 15th Amendments by utilizing the interpretation of state action. This is specific during the Civil Rights era. Another example, the current Texas abortion law, which attempts to avoid judicial review. And third example, we had a little laugh. The filibuster can be used occasionally for positive things, but Senator Thurmond's use of the filibuster to hold back the Civil Rights Act in 1957, the longest filibuster to date.
Well, those are two very important subjects, and the first one has to do with the incredible limiting of the potential of the 14th Amendment and the Reconstruction Amendments that occurred in the second half of the 19th century in order to essentially had to do with the election of 1876. It was a deal that was cut to allow a Republican to win the election, and they basically gave back the right to vote issued to the South and let them use absurd techniques, Jim Crow and others, over time that should not have been allowed at any time in American history. And of course, the battle that had to be fought to get the Voting Rights Act, to get the Civil Rights Act, has been chronicled from the 50s and 1960s. And, you know, to finally get that done and to have that be sort of a bipartisan repair of the damage that was done in the 19th century was a very major achievement. You know, when I was in the Congress, the Voting Rights Act had to be regularly renewed. It was always overwhelmingly bipartisan. In fact, one of the most conservative members of the Wisconsin congressional delegation ever, a guy named James Sensenbrenner, he and I didn't agree on anything. He was a total pain in the neck. He considered me a pain in the neck, but he took great pride as a member of the Judiciary Committee of helping to co-author appropriate reauthorization of the Voting Rights Act. This is what was destroyed in the Shelby County case, which was turning out to be one of the worst decisions in the history of the Supreme Court. And here, Chief Justice Roberts has been, even though I see his independence on some things, he's an engineer of some of this damage that's being done. And so what we have now is something that the court allowed and encouraged. And so then you kick it back to the Congress again. They say, well, the Congress can do this. Well, how's the Congress going to do it if you have a filibuster? And so that goes to the question of what the filibuster is. Filibuster, as I'm sure you guys all know, is nowhere in the Constitution. It is not guaranteed. In fact, it's an odd type of parliamentary procedure in almost every parliamentary body in the world. After a certain amount of debate, somebody can raise their hand and say, Mr. President, I call the previous question. That means let's vote. Let's vote now. Our founders in the first few years of the country decided that in the Senate, you couldn't do that, that there was unlimited debate. But it really wasn't a big issue until the 20th century. And in the actually the whole idea of limiting debate by cloture, you know, the vote, supermajority vote, that came up in the context of World War I. It was actually a bunch of progressive senators like La Follette, I got a picture of him here from Wisconsin, who were trying to prevent us from going into World War I. And President Wilson was upset. So he got the Senate to create some kind of limit on debate. That's really where this idea of limiting the filibuster came in. So there was no constitutional protection for it. And of course, the most infamous use of this was for this very subject. It was the Southern senators repeatedly using the filibuster to prevent Voting Rights Act, civil rights, the first Civil Rights Act, things that Lyndon Johnson actually switched sides and ultimately made sure happened. And so what you have now is a filibuster that is actually not applied to everything, but is still being applied to something like voting rights. And there is no excuse for not making an exception to the filibuster rule for voting rights. It's a constitutional right. You know, we were kidding around before. Yeah, sometimes it's not a harmful thing. It's when it's used honorably. It's usually when a certain senator is trying to protect his or her state. I did it once. You know, we have a lot of dairy cows here in Wisconsin. We're the cheese state. We got the cheese heads for the Packers. Well, a couple of the senators up in Vermont were trying to get a better reimbursement deal for Vermont that was going to hurt Wisconsin. I was a senator from Wisconsin. I had to do something about that. Their names, by the way, were Leahy and Bernie Sanders. They were my enemies on that one. Anyway, they were trying to screw up this thing. And I got up there as an individual senator defending my state. And I had my staff get me cheese recipes and a book on the history of cheese. And I got up there and I started reading this, you know, and I did it for about 2 or 3 hours and I finally gave up. But, you know, everybody gets that. And this was only once in a while. Now what you have is they don't even have to do anything. They don't even have to speak. They just say, I'm going to filibuster. And the idea that this would be applied to voting rights is an outrage. As Reverend Warnock, Senator Warnock has said, the idea that you're going to protect the rights of the minority in the Senate to deny the rights of the minority across the country is an absurdity. So I think any senator that insisted on this filibuster here should be ashamed of themselves. This is an abuse. You don't have to eliminate the filibuster completely, but that's what's going to happen if they continue to use it to deny the fundamental rights of the American people. So the court kicked it back to the Congress, and the Congress is being blocked by this filibuster. So you have to unlock that. So you can force the court to eat its own words. And they said, well, you didn't say it this way, or now we're saying it this way. Now you have to accept it.
That's great context. Focus on just opening my mind up to the misuse of the filibuster rather than a outright ban of the filibuster, because there are scenarios where it's meaningfully used. And also quickly, something that Professor Cox Alamar, our constitutional law professor, one of our constitutional law professors, which I believe did a Puerto Rican statehood event with ACS maybe a year or two ago. We've had a few discussions in class. Again, we all come from different backgrounds. We have different opinions, but there was one concept that kind of struck me, and it was to part of your point, Russ, the back and forth between the legislature and the judicial branch in trying to establish rules of law. And this is my opinion, in the ineffectiveness of the legislature in passing laws, and then the pressure put on the judicial, you then have the executive branch towing the line where they become essentially legislatures, which in my opinion, that's not the bounds of their role within the Constitution. So just something that struck me from conversations in class and something that you shared. But that's all I have.
No, that's a good point. I mean, that was a big source of controversy under President Obama, because you had this constant silent filibuster denying everything he was trying to do. And so he tried to push the limits of executive orders. Some people say it went too far. Now, there are legitimate executive orders and there aren't. But the reason he did that is not because he wanted to do it. It's because he had no other alternative. You've got a right-wing Supreme Court. You've got a do nothing or Tea Party Senate and House during that period. And he's like, I was elected overwhelmingly by the American people to try to solve these problems. So yeah, I think that's a good point the professor makes, that it kind of creates this balloon pressure that goes over to the executive side. That's a really interesting concept.
Thank you. You got it, Domonique.
So President Feingold, you kind of already answered my next question regarding the filibuster. It was more so going to be, do you think that it should be eliminated altogether? I know Shawn was pointing out, there are some positive uses for it, but do the pros outweigh the cons?
I used to think that you had to keep it. I am mixed on this now. I mean, we have to remember, not only is it doing horrible things now, and not only has it provided protection for anti-civil rights laws in the past, we have to remember how grossly malapportioned it is. So you already have a situation under the Constitution where every state gets 2 senators. So that means California has 2 and Vermont has 2 and Montana has 2. Okay, that's crazy malapportioned. But let's say we think, okay, that's the way the Constitution was set up. That's the deal. We have to keep it. In fact, if you look at Article 5 of the Constitution, the most amazing thing, the only still existing provision that says you can't change it, you can change everything else in the Constitution. The one thing you can't change is that states have equal representation in the Senate. It's, quote, unamendable, which is phenomenal. All right, let's just say for a moment, you could have a constitutional amendment to change Article 5. And, in other words, you could eliminate that, and then you could go back and change it. It'd be very hard to do. But what the filibuster does is it multiplies what is already a crazy malapportionment even worse. So it says not only does every state get 2 senators, so there's a huge advantage for rural areas, but this means you have to have 60 votes to undo that. So this is like laying malapportionment, gerrymandering on top of gerrymandering. So it makes it harder to defend the filibuster, even though, as I said, there are times when it's used. Now, look, I'm going to give you one example where I saw its value from a progressive viewpoint. In 1994, the contract with America, which was Newt Gingrich and the right-wingers taking over the House and the Senate, they wanted to undo a lot of the labor laws and environmental laws of the country. And I was a brand new senator, you guys, so I was kind of nervous about speaking on the floor. All of a sudden, my chief of staff says, "Senator Kennedy wants you on the floor right away." It's Ted Kennedy. I was moving fast. I get down there and he said, and this was a bill that would have taken away various protections for workers' salaries and pay that had been there forever. And Davis-Bacon Act, I think. Anyway, Kennedy says, "Oh, the new senator from Wisconsin's here, and he's going to give us a speech about this." So I got up and, I spoke against the bill for about 5 minutes. And he was sort of talking to his staff. And of course, he was a hero of mine, but he wasn't really paying attention. And then I stopped and he looked at me and he goes, what are you doing? Keep going. And I said, "Well, I don't have anything else to say." And he said, "Russ, we don't care what you say. This is a filibuster. We're trying to prevent these guys from taking away all the labor laws and environmental law." So there is that piece of it, but I'm trying to give you the sense that you said it exactly right, Domonique. What's the balance? At what point do you say, okay, maybe we're going to lose some of those laws? And as you can see, I'm very basically tormented by it now, because I always thought it was important to protect progressive legislation, but the malapportionment is so obscene that it's hard to justify.
Yeah. I mean, while there are pros and cons, there should, just like our government, there should be limitations placed on, when it's used. So,
yeah, and a point on that to make is, the filibuster doesn't apply to everything already. It doesn't apply to the Budget Act. It doesn't apply to certain trade stuff. It doesn't apply to nominations at all anymore. So it's not like it's the end of the world if there was another exception or two. Then the question is, what about if we got rid of it? You asked it well.
Yeah. Thank you for your answer, President Feingold. I'm going to turn it over to Shawn to go over the question for judicial norms.
Thank you, Domonique. So this question is from Kendra Lee from UDC ACS, and she asks, ACS has positioned itself as an alternative and counterweight to the Federalist Society, which has been successfully pursuing a long-term, well-resourced, and many would argue, unscrupulous campaign to exert influence on the courts and overall system of United States jurisprudence. Examples are the multi-year organized effort to get conservatives onto the federal bench, a scorched earth battle to limit abortion rights. So her question is, does ACS have a long-term strategic plan equivalent in scope and impact? If so, what ways and means and lines of effort has ACS identified towards those objectives? And what concrete actions can us as students take to make an impact?
Well, in some very difficult times, this is one where I can say yes. We are meeting the moment in a very important way. The American Constitution Society is the driving force in this country in making sure that President Biden has the recommendations he needs to undo the damage that you just described. And so the way the Federal Society did this is they had very wealthy billionaire donors in backroom conversations make young law students like yourself agree to certain principles, and in return, they would sort of protect your path to a big judicial spot. We don't do that. We use a grassroots approach. What we did is we have some 50 lawyer chapters. We asked these lawyer chapters to create working groups in the communities. And so it's in Texas, it's in Florida, it's in Arkansas, it's in California, it's in Wisconsin. And it isn't just the lawyers in ACS. They went out and they said, let us meet with African-American groups, let us meet with Latino, Latinx, Latina groups, let us meet with LGBTQ plus groups, let us meet with union groups. Let's get in a room and have you tell us who you would like to see on the bench. And typically, of course, people say, I'd like to see somebody who looks like me occasionally. I'd like to see somebody who's represented somebody that looks like me occasionally. And so what we did, and it was a long-term plan that culminated, and we're continuing it permanently, but over the 2 years of the final 2 years of the Trump administration, we put together a list of 400 names that were sent to the Biden transition within 2 hours of his being sort of named the winner the week of the election. You know, it's Saturday after the election. And as soon as they got into the White House, they continued to work with us. We meet almost every week, constantly providing more diverse names, and they're diverse in terms of background, racial background, ethnic background, and also in terms of the kind of work they've done. And so sometimes they'll say to us, as they did recently, we need more Latino and Latina names. Can you help us? We go back to our chapters and do it. So it's a very dynamic process. And the results are fantastic. Of the three things so far, of the three things that people are giving the Biden administration credit for, the primary ones for victories are the COVID-19 legislation, the infrastructure legislation, and the success on judges. Biden broke all the records of modern times for confirmations of judges, the number and nominations, but it's better than that. The vast majority are women. The vast majority are people of color. We now have numerous African-American women on the courts of appeal for life. I think more than all combined in the past, just from that first year. And so you guys, we are doing this. There are others doing it, but we've done it more than anyone else through these working groups. And it makes me feel so good because this is exactly what the questioner suggested. Now, I'm not going to pretend that it doesn't get tougher now. It does. Because a lot of those ones were ones from so-called blue states where we don't have a problem with red state senators blocking them. But we're not leaving that. We're fighting not in Georgia anymore, but in Florida, in Texas. There are openings, Kansas, all over the place, where we are fighting to make sure we can get President Biden to be able to get more diverse nominees on the bench. So look, we got a lot of damage to undo. But one of my decisions as president was, you might have thought these working groups would work and then they'd be done. No, they are permanent, because we don't just need to do this at the federal level. We have to do it at the state level. We have to do it for judges. And I was on the phone the other day with New York. I've done it with California. We have to fight this battle at all levels like the right does. And we're determined to have a grassroots organization that continues to uplift progressive, diverse candidates for judgeships. And I know this is something your chapters are interested in. In fact, you're going to be doing a program on clerkships in the near future that is an exciting example of how this pipeline works. So I get excited about it because I think we're having genuine impact here.
Thank you. We're going to do one more question for me, and then Dominique's going to wrap it up, and then we'll open it up for questions for the attendees. So last one on the UDC ACS end is from Wayne Lawson. He asks, what is your perspective on actions to improve participation in local elections? For example, school board, election supervision, or maybe a federal voting holiday.
I think we need to have things like a federal voting holiday. I've thought that for a long time. One of the things we do in ACS is we try to get classes canceled in the law schools on the day of the election so students and professors can participate in voter protection. And I think that we have to continue to do that sort of work if we're going to be able to protect our elections.
Yes, and that's something Constitution in the Classroom, something that our chapter has taken on.
Getting students at a younger age to understand what the heck this is all about. That's a very successful program. So there are a number of initiatives we have in this regard, but we intend to up this a bit this year. We are going to institute a new program called Run, Vote, Work, where we try to pull together what we do to make people realize it's not just a governor race, it's not just a senator race, it's not just a president race. It's the race for the school. It's who the district attorney. It's who works for the district attorney. Are there progressive lawyers in that office? So we believe that getting people to realize the importance of things like Secretary of State offices that people might normally ignore, we want to highlight those in a way to get people to realize that it's not just voting for the top people, it's actually some of the others that may be even more important.
100%. Thank you, Russ. And jump it to Dominique to finish it off.
Thank you, Shawn. I just want to go back a little bit to what you said, President Feingold, about the
Russ is good. Russ was good.
Yeah, Russ is good about there's not enough Black women on the Court of Appeals in the circuit currently, and there's only ever been 11 since the inception of our nation. And President Biden has elected 3. So I definitely think that there needs to be more work for diversity across all boards of the legal field. And that's something great about ACS, because you're definitely, making those moves to open more doors for diverse students such as myself and Shawn. So definitely commend you for that.
You got to love it. The Senate vote on one of those and you realize this person's on for life. That feels good.
Yeah. So the last question I wanted to ask, this is from our member, e-board member, Tavius. So how did the events of 2020 and the pandemic change how ACS goes about accomplishing its core mission?
Well, of course, part of this I have to get from people's accounts of the past, because as I told you, I started on March 9th, 2020. So the only world that I've lived in for ACS is this one, but I can tell it was very difficult and continues to be difficult sometimes for our chapters because people couldn't meet in person. And a lot of what goes on, and I did teach at 4 or 5 law schools, I can see that ACS was place for people who were like-minded, got to know each other, and at social events as well as programming. So the bad news is that was disrupted, and that it started coming back, and it's being disrupted again. But we are amazed at how well the chapters have done to keep themselves going, to elect new officers, to have good programs. And here's a little bit of a silver lining. It led to much more connecting of chapters across the country, a lot more because of Zoom. You wouldn't maybe have thought in the past of having an event with all the California Bay Area chapters inviting somebody else. Well, they invited West Virginia on Monday. And I'm on the line here, and there's like 100 people, like 40 of them are from West Virginia. even though the program I think might have been Berkeley or whatever it was. So there is a way in which this has led this to become a little bit more of a national network. And I, for one, believe you have to have the in-person, but I think the whole idea of this kind of technology to bring people together and to get people to know each other really can be very good. And so in the end, if we get through this, I think this will be a way in which the organization grows in a positive way, as long as we can get back to the in-person. And one of the initiatives that I've pushed is getting, I want to get this signal out there. We're going to have more and more funding from the national to reimburse the student chapters for speakers. In other words, you can arrange for, let's say, 2, if we're going to have some pilot chapters, and one of them I think is Howard. So what you can do then is know a year, like if you are starting in the spring, look into the next year, look, ACS National is going to reimburse us for flights, staying overnight, food, basic expenses. So you can get good speakers in, and we can help you with trying to line them up. So we know that it's not just students meeting with each other, but sometimes they like interesting speakers come from other places. So that's one of the initiatives I've been pushing very hard.
Yeah, Howard is one of those pilot programs, and we've been very blessed to have additional funding to be able to invite these speakers and house them and have them come speak to us. So definitely, definitely happy about that. So to wrap it up, we're just going to open the forum to all of the attendees to submit questions that you want to ask Russ for these last about 10 minutes. So if anyone has any questions, you can submit them in chat, and then we can ask Russ.
Did we answer all the questions?
Yeah, we pretty much went through. I don't know if you have any closing remarks before anyone submits any.
I just want to say, if I could, what an enjoyable event this was. And I love the work you're doing at these chapters. It's not only interesting, it's very meaningful. I mean, you folks are getting off to your careers in a really positive way, where you're already thinking about how you can create change, but you're taking the law seriously in a way that is exciting to me. And I just really want us to help you in any way we can, because you're certainly helping us live up to our mission. So I'm basically just saying thanks.
Thank you as well, President Feingold.
We may have a question. It looks like this is from John Bell. He is the treasurer of UDC ACS, and he asks, which is the most important amendment, or what amendment would you propose if you were the convention decider?
There's so many that I think really are important, and among the nominees would be one about the environment, climate. Another would be to ban the death penalty. Another one would be to get rid of the Electoral College. But I'm going to say the one that, if I could put it in there today, it would be a constitutional right to vote, because it's not in the Constitution now. And that's how these guys get away with this, is that it needs to literally be guaranteed in the Constitution itself. And so I change from time to time because I want all of them, but I think I'd pop that one in there right now. But the language would be interesting, because you want to make sure that it doesn't allow them to get around it at all.
Thank you. It looks like there's another question in there. Domonique, you want to present it?
Yeah, I'll read it out. So this one's from Anonymous, and it says, Senator, can you speak more about the ACS work on voter protection? Are you micro-targeting critical countries, and how do we get involved?
Now, our role is not to target in the political sense. We are a 501c3, so we don't sort of get directly involved in elections per se. But what we do try to do is provide as many opportunities as we can for our student chapter people and lawyer chapter people to get involved in things like voter protection. As I mentioned, one of the things we do is to try to get the law schools to cancel the classrooms on election day so that students can participate. We also partner with a range of groups that really are at the forefront of trying to protect the right to vote. We don't try to reinvent the wheel. We are partners with them during the election period, and we will see that a great deal this year. So yes, we're a place where if somebody wants to contact us or somebody wants help, we are a good clearinghouse for helping get volunteers to help with the integrity of the election process. But we don't endorse candidates, and we don't do sort of targeting of political targeting. But let's say there's a place where there are really bad abuses in terms of poll workers and so on. That might be a different story. That's where we might try to direct volunteers to provide voter protection.
I think that was a great answer, President Feingold. There's no more questions at this time. So
thank you very much.